worried that I'm gonna like miss something. But then my brain's gonna think.
It is like the smallest of the three. But things done, so I can just get to the stuff that's gonna take there, so I have.
Chainsaws.
We're all just sort of. Yeah.
Jonathan, can you hear me? Oh, there's a microphone.
Oh my god, why is it? This shouldn't be hard.
Okay, cool.
You're fine.
Here. Right here. Oh, yeah.
Hey guys, how's it going?
Good, how are you?
You
You know.
immediately said. So,
I was
let's
saying-
raise-
It is over, yeah, I'm gonna, no, it is right now. Handling the clicking. All right, Jonathan, can you hear me?
Yeah, I can hear you.
Okay, all right, thank you, everybody. We're gonna get started with our presentation today, and Jonathan, I will hand it to you to get us started.
All right. Good afternoon. My name is Jonathan McClellan, alum of UST School of Law and president of the Minnesota Justice Coalition. We are part of a collective of organizations that work with the community and families to educate, draft, and advance legislation and other policy initiatives at the Capitol in St. Paul and in Washington, D.C. We are also home of the Investigative Workgroup that does some amazing work. Thank you all for joining us today for the third session of our four-part series on civil versus criminal liability for police officers involved killings. It is truly an honor to be here with such a dedicated group of students, community leaders, and organizational advocates who are committed to deepening our collective understanding of the critical intersection between law enforcement, accountability, and justice. This series was designed with one central goal: to educate and empower all of us. Whether you're a law student, a community leader, or someone working within organizations that aim to reform and advance justice. These are not just theoretical concepts, they are real, practical issues that affect countless lives every day. Understanding the law in this area is essential to meaningful change, and I'm so glad to be a part of this discussion with all of you. Today's session, like the ones before, is led by experts in the field who bring an incredible depth of knowledge and experience. I am excited to introduce today's presenter, Emma Pedersen, a leader with the Minnesota Justice Coalition and the Reinvestigation Workgroup. Emma has been at the forefront of advocating for justice and accountability, and I know her insights today will provide invaluable knowledge about civil and criminal liability when it comes to police officer-involved violence. Before we dive in today's presentation, I want to take a moment to express a heartfelt thanks to the collaborators who helped make this series possible: the Community Justice Project at St. Thomas and the Truth in Action Project at Mitchell Hamlin. Their partnership has been an essential in creating this series and in fostering the dialogue we're engaging in today. We also owe a special thanks to the students who have given their time and energy to help bring this event to life. Your commitment is truly appreciated, and this series wouldn't be possible without you. As we move into this important discussion, please remember that this is a space for conversation, one where we can ask questions, challenge assumptions, and work together to find ways forward. And while today we're focusing on civil and criminal liability, I encourage everyone to consider how this fits within the broader context of law enforcement reform, racial justice, and systemic accountability. Next in our session, we will be addressing qualified immunity, a topic that is both timely and critical in the conversation around police accountability. But today, let's dig into specific legal frameworks and their application to cases of police violence. And more importantly, let's think about how the law can evolve to better serve justice for all. Now, without further delay, I'm excited to turn it over to Emma Pedersen, who will lead us through today's session. Emma, the floor is yours.
Thank you, Jonathan. Before we get started, I also want to recognize Nicole Kessering, who is the Reinvestigation Director for the Reinvestigation Workgroup, and we are a group of all volunteers who re-examine cases of police violence after the official investigation is over. And Nicole has been leading the charge with us here, and we've been doing this for 7 years now. Yes, and we do this as a family, so she's my godmom.
And we also have
We also
members of the reinvestigation group here today, and I'd like to thank them as well as online.
Yes, and also, yeah, welcome to the students walking in. Yeah, we just really want to shout out our students with the Community Justice Project here at St. Thomas. They've been invaluable with helping our work group and doing this type of work and what we're going to talk about today. So, yeah, you want to go to the next slide? So we're gonna get into first civil and criminal liability and kind of exploring the differences when you're looking at what happens when the police kill. And so we're gonna specifically start this case off talking about the case of Marcus Golden. So Marcus Golden, it's kind of why Nicole had the idea to design this series. So we've been advocating for justice for Marcus Golden, who was killed by the St. Paul Police Department in January of 2015. His case was the last case where the St. Paul Police Department investigated themselves, and a grand jury actually cleared the officers of criminal wrongdoing in May of 2015. And when I say they cleared the officers of criminal wrongdoing, I mean they declined to press charges. That's what that grand jury was. This was not something where there was a full trial. It was a grand jury, and we're going to talk about more about what that is in a second here. So what happened with Marcus? His family filed a lawsuit. They actually filed the lawsuit after the 3-year statute of limitations. So again, we're going to get more into the details here. But there is a 3-year statute of limitations for a civil wrongful death suit when someone is killed in Minnesota. But the family was able to get an attorney who found an exception to that statute, or to that rule. And that was the murder exception. So we were able to move forward and show that if you can prove it's an intentional act constituting murder, there is no statute of limitations on murder. And this is all civil liability, which again, we're going to get into. So the family was able to go forward that way. And then in January of 2023, the city of St. Paul agreed to a very unprecedented $1.3 million settlement with the family. Why are we still talking about Marcus, you might be asking? Because it's settled, right? Well, for us, this is not just about money damages. This is not just about money at all. It's really about pushing forward policy change and pushing forward justice and accountability. And we're going to get more into the details of what happened to Marcus in a bit here, but we are pushing along with Marcus's aunt, Monique Colors Doty, who wasn't able to be here today. We're pushing for criminal charges for the officers who killed Marcus because what happened to him was absolutely egregious and criminal in our opinion, and based on our investigation into his case. Okay, so before we kind of return back to the case, part of the reason why we're here today is because when we were advocating for Marcus Golden, we had a meeting with the Attorney General of Minnesota. And one of the things that came out of that meeting was that we need to do more education in the community of the civil versus criminal liability in these cases. And so that's what we're going to be talking about today. And we also want to educate our community partners and the family members. We have a lot of family members of people who've been killed by police violence online with us here today. So this is for law students, but it's also for families because we want to empower them to understand these systems. So there's the civil and there's the criminal system. Most of us who are in law school will know the civil system is about resolving disputes between private parties. And then the criminal justice system or legal system is where the state punishes private individuals for offenses that us as society deems wrong. And I put a hard asterisk on that. You can go to the next one. So the goal of the civil legal system is to make a person whole. So there's two main goals there. There's compensating somebody. So that's what we think of with money. And then there's also deterrence. So you can get like compensation, you can get the value of what somebody would have been worth to you. And then you can also get more deterrent stuff. So that'd be like punitive damages, where it's like we want to punish an officer for their egregious conduct and prevent them from doing it again. So that is the civil system versus the criminal system. Criminal punishment is more of an expression of the community's judgment, their condemnation, their hatred, their fear of somebody who engages in what we all deem as prohibited conduct. And this is all theoretical, and it plays out a lot differently, as I'm sure we all know who have studied the criminal legal system. So going further into the differences, who brings a suit in a civil case? That's going to be the victim's family or the estate. And so that requires the family to get together, to pick somebody, appoint somebody as a trustee for that estate. And then they bring a lawsuit. They have to go find an attorney and they bring a lawsuit on behalf of their loved one who died. Who brings the suit in a criminal system? That's going to be the government. And in these types of cases in Minnesota, it is more often than not the county attorney of whatever jurisdiction that person was killed in. The only times you'll see kind of that differ is if there's like some sort of conflict, as there was in Marcus's case, for example. In Marcus Golden's case, it happened in Ramsey County, but the father of one of the officers involved was an investigator for the Ramsey County Attorney's Office, so it got punted over to the Washington County Attorney's Office. So looking again at the statute of limitations between these cases, so for a civil case, there's a 3 to 6 year statute of limitations. So the 3-year statute of limitations is the state wrongful death claim. And then you can go up to 6 years for some other claims that you could bring, such as like negligence, which I won't get into that. You can't really bring a negligence claim here, or like battery and assault. And then for criminal legal system, there's none, at least for murder. Sometimes with manslaughter, that looks a little bit different. And then the burden of proof, which is really important when you're looking at the differences between liability in police killing cases. So for the civil system, the plaintiff has to prove by more likely than not, or by a preponderance of the evidence, that the officer committed a constitutional violation. With the criminal system, they have to prove it beyond a reasonable doubt, not only that the officer committed a crime, but also that the officer isn't allowed to have the affirmative defense that they were justified in that killing. And we're going to get into that state law in a little bit here. So again, just a little bit more information between the systems, the source of law when you're looking at the civil system and what a family would bring a lawsuit under. We're really looking at federal civil rights law, and it's called Section 1983 law. That's really where you're going to look for the claim to bring that on. So that's going to be your main claim. And then families will also bring like the state claims, which is wrongful death, battery, assault, those types of claims. And then for charging an officer criminally, again, you're going to look mainly at the state criminal statute. And then sometimes you can also look at federal criminal statutes. There's also some federal criminal, like civil rights statutes too, that are sometimes brought. And you'll see that in the case, for example, of Derek Chauvin and the officers that were involved in killing George Floyd. They had federal criminal charges brought against them. So looking at the kind of the standard of review in these cases, we first, for the civil system, we want to know, did the officer violate somebody's constitutional rights or commit what's called a tort? And a tort is a legal wrong. And for the criminal system, it's did the officer commit a crime? So again, what are the possible outcomes that we're looking at in these cases? For the civil area, a family can get money damages or policy changes. And we believe that they should always bring both. You know, that is the goal here, is we want policy change along with compensating the family for their loss. And then for the criminal system, obviously conviction, if you get a conviction, you can get prison or probation or fines as well. All right, so looking more into our case study for the day and looking into this issue of statute of limitations. So Marcus's aunt was appointed the trustee for his family in Marcus's case. Again, he was killed in January of 2015. What had happened in his case was there was a 911 call about somebody was outside of an apartment around 2 in the morning that was supposedly sending some threatening text messages to somebody who was safely inside of the building. So you had some officers respond to that call. The officers self-assigned themselves to the call. They weren't assigned by dispatch. They elected to go. And it was aired over the radio before they went there that Marcus had previously threatened to kill officers. So the officers show up, they don't turn on their lights, they don't turn on their sirens, and because they didn't turn on their lights, their in-car camera didn't come on. And this was at a time when there was no body-worn camera footage, and there, in this case, was not any squad camera footage. So they go and they approach Marcus, who's at the end of the lot, and then this is where it's disputed about what happened. The cops say that they got out of the car, they tried to tell Marcus to get out to stop, and then that Marcus drove at them. And then the officers were in fear for their life. They were in fear of getting run over. And that was the reason why they shot the officers. And what we were able to do, what Nicole was able to do in particular, was to look at the physical evidence. And we looked at the tire tracks in the snow, because thankfully it snowed that day. We looked at the tire tracks in the snow and the footprints in the snow, and we're able to show that Marcus did his best to drive all the way around the officers, that he was never driving at them, and he was also shot when he was, what is it, 150 feet?
80 feet away from the officers.
180 feet away from the officers. He was driving away from them, was no threat to them. So that's kind of the case summary of this one. Paul Bossman was the attorney on record for this case, and he took this and he again filed, attached a wrongful death claim to the family's already filed suit. And because it was past the statute of limitations, we argued that there was no statute of limitations because it was an intentional act constituting murder. And that was preserved here. It was never challenged because this case settled. So this is a huge tool for families. Can we go to the next slide? So this statute of limitations things is a very big barrier for families. 3 years is not a long time. Especially when you're grieving the loss of your family member. Many families really struggle to get through that grief, to be able to get through the funeral and get through all of that. And while they're doing that, they also are trying to get data from the government about what happened to their loved one, and find a lawyer who will review their case, which is really hard for families to find an attorney who will look at their case, especially if it's a difficult one where there's facts in dispute and there's a very present police narrative about what had happened to their loved one. Okay, so going back to kind of our discussion of these legal standards, we want to really point out that the biggest standard or the biggest difference between civil and criminal liability is burden of proof. So in these cases, everything is evaluated under the Graham v. Connor objective reasonableness standard. And if any of you were at the first session, we went into that in a lot of detail about what that is. And so what it comes down to, that objective reasonableness standard is applied in civil cases and it's applied in criminal cases. But in the civil case, the plaintiff must prove by preponderance of the evidence that officer committed or violated their constitutional rights, whereas in a criminal case, the prosecution must prove beyond a reasonable doubt, which is a much higher standard, and it's why we don't see a lot of criminal charges being brought in these cases. So kind of going into a recap of what that civil liability looks like. Most commonly officers are held accountable in the civil legal system. If you look on the graph here, this is from the Mapping Police Violence US. You'll see for criminal accountability, there really is not a lot. So 98.2% of police killings from 2013 to 2024 have not resulted in an officer being charged with a crime. I think we're kind of in an anomaly in our state that we've had a few officers being charged and some convicted, but that's an anomaly. You can go to the next slide. Okay, so when we look at these cases, this is what the legal standard is. An officer's actions are analyzed by whether they were objectively reasonable in light of the totality of the circumstances. And totality of the circumstances includes these three things. This comes from Graham v. Connor, which is the severity of the crime at issue, whether the suspect posed an immediate threat to the safety of the officers or others, and then whether they were actively resisting arrest or attempting to evade arrest. There's some other things that aren't in that list though. The officer's training, the officer's experience, what the officer knew at the time. And we really emphasize those because we know that policing has changed a lot since Graham v. Connor was, this decision came down from the Supreme Court in the 1980s. We train our officers a lot differently now than we did in the 80s. And so we try to emphasize that when we talk about what is objectively reasonable. Okay, so for criminal liability, what is actually more important is the state deadly force statute. And so our deadly force statute is Minnesota Statute 609.066. So this is an affirmative defense. And so what that means is that an officer can be charged with a crime and then they have the burden of saying, hey, I acted in defense of myself or others. And this is this explicit carve out for law enforcement here. And then the state has to respond by disproving it beyond a reasonable doubt. So in a lot of these cases, what'll happen is even if a prosecutor says, yeah, I can prove that they, met the elements of murder, I can't disprove that the officer was entitled to this defense. So we've had some significant changes in our deadly force statute within the past 5 years. We're going to start with the old standard. This is before the state law was changed in 2020. And so under this old standard, an officer was justified in using deadly force only when necessary to protect the peace officer or another from apparent death or great bodily harm. There's also another subpart of the statute about a fleeing felon. If the officer uses deadly force to arrest that person because they have probable cause to believe that they have committed or will commit some sort of violation that amounts to deadly force, then the officer is also justified in doing that. I want to point out the apparent word here. This word was extremely problematic. It was just actually reintroduced in the legislature just this year that they wanted to put this word back in there. And the problem with it is that it introduces subjectivity into the law. So as we saw from the Graham standard, which is what all use of force should be looked at, whether it's civil or criminal liability, it's an objective standard. The word apparent here asks us to look into the subjective judgment of the officer. And so, that created a lot of problems with, officers just saying, oh, well, I was in fear for my life. And that's kind of their get out of jail free card. So in our investigation of Marcus Golden, the reason why we are advocating for criminal charges in this case is that Marcus was killed in 2015. So this old law would apply here. And what we were able to show based on the forensic evidence in that case is that Marcus Golden was shot while he was fleeing and when he posed no immediate threat to the officers or to anybody else. And so we believe that the tire tracks and the bullet trajectories really suggest that Marcus was trying to avoid the officers when he was shot from behind. And that's kind of contradicts the officer's claims that he posed a threat. And so that is one of the reasons why we're really trying to push that for Marcus's case, and we're really advocating for it, is because we believe that those officers murdered Marcus Golden. Okay. So what changed? So in 2020, with the Reforming Police Accountability Act, it passed through the Minnesota legislature. Part of the changes from that act were changing and amending our deadly force law. The goals of it were to codify Graham v. Connor in our law. It was also to, really embed in there that we need to respect the sanctity of human life. And they really wanted officers to only use force when it was kind of the last resort and the last means necessary. And so now what our statute reads is that an officer is justified in using deadly force only if an objectively reasonable officer would believe, based on the totality of the circumstances known to the officer at the time and without the benefit of hindsight, that it's necessary to protect them or another from death or great bodily harm, provided that the threat can be articulated with specificity. I'm leaving out this part because they wrote this part in there. Actually, our police associations in our state were part of drafting this law, put this in there, and it turned out to be unconstitutional to their own officers, so they got rid of it. But yeah, so that's the first prong. The second prong is that it's reasonably likely to occur absent action from the law enforcement officer, and it must be addressed through the use of deadly force without unreasonable delay. And what the goal of those last two prongs is that the threat has to be imminent. Like, it has to be in that moment. So an officer can't say, like, oh, well, he was threatening to kill somebody hours earlier. I saw him brandish a gun and point it at somebody or shoot at somebody hours earlier. That's not going to cut it. It has to be an imminent threat. Okay. So kind of the other important parts about this new law is that there's 4 paragraphs of legislative intent, which is new. Minnesota, the way we write our statutes, we don't really like to put legislative intent in there. Our legislature really likes to be clear, but they thought in this case that they really needed to make it even more clear about that they wanted to restrict the use of deadly force when it was truly necessary. Yeah, I think I've talked about the other points, so we can go on from there. Okay, so let's apply this new law to a case. So Amir Locke was killed on February 2nd of 2022. What happened is the Minneapolis Police Department executed, on behalf of the St. Paul Police Department, a no-knock search warrant at an apartment in downtown Minneapolis here. MPD SWAT officer Mark Hanneman shot 22-year-old Amir Locke during the execution of that no-knock search warrant. Amir was, before the officers entered, he was sleeping on the couch of his cousin's apartment, and then the officers came in, entered the apartment, and then within, what was it, 9 seconds? 8 seconds, they shot Amir. You wanna go to the next slide? Okay, so in this case, it was interesting. The new law had just passed, so it was kind of like, all right, so how do we evaluate this use of force? So the Hennepin County Attorney and our Attorney General both evaluated the use of force in this case, and they decided that criminal charges would not be appropriate. And this is kind of what their analysis came down to. They first looked at, was deadly force necessary to protect against an imminent threat? The prosecutors examined whether Amir posed an immediate threat by looking at the facts that he was, lying under a blanket and that he was holding a legally owned firearm when the officers came into the apartment. And they concluded that, based on the fact that he was holding that legally owned firearm, correct me if I'm wrong, that Officer Hanneman's perception of an imminent threat could not be disproven beyond a reasonable doubt. And so your ears should be kind of going up, but it's like, hey, it's an objective standard, right? Like, why do we care about the officer's perception? And one of the things that we took issue with when we looked at how the AG and the Hennepin County Attorney were applying the new law is that they were putting this apparent threat language back into the analysis, even though we passed the law, changed the law to take it out. And the reason that they did that is because that legislative intent that I was talking about, that part includes the word apparent, even though the actual actionable subdivision of the state law doesn't. And so we believe that it was misapplied. The new law was misapplied here in this case. So some of the other stuff that they looked at was the second prong of the new statute, was the threat reasonably likely to occur? They said that Locke's movements, he was emerging from sleep and he was holding a firearm. Those were assessed to determine if they indicated that Amir was going to use force. And they couldn't find no clear evidence that Amir was going to fire, but they ruled that Hanneman's fear of it was not legally unreasonable. And then they also, for the last prong, cited that because this all happened so quickly that officers are allowed to make split-second decisions. And so they decided to not charge Officer Hanneman. Just one more quick note on that. The family has a civil lawsuit against the city and against Officer Mark Hanneman. Just this past week on Tuesday, they were in front of the 8th Circuit Court of Appeals arguing this case because initially they moved to kick out the lawsuit early on a 12C motion, judgment on the pleadings. The judge said, nope, you need to continue forward, go to discovery, keep going. I don't see enough evidence here that you should get your complaint dismissed. And so the city appealed that. So we'll see kind of what happens in that case. And we are watching that one very closely. Okay, I just spent a lot of time talking at you. Any questions on civil and criminal liability before we go into kind of the meat? Not the meat, but what really happens when someone gets killed in the state. Any questions, or online, any questions? Okay, no? All right, and feel free to interrupt me at any point in time with questions. Okay, so what happens when police kill in Minnesota? So in the state of Minnesota, we have a state crime bureau called the Minnesota Bureau of Criminal Apprehension. And since about 2016, they have investigated police killings in the state of Minnesota. Before then, law enforcement agencies typically investigated themselves, or for example, if Minneapolis killed somebody, they'd have Hennepin County, their neighbor and their partner, and a lot of things investigated for them. And I think the last case in St. Paul where they investigated themselves was Marcus, as we stated, and then in Minneapolis, it was Jamar Clark, who was killed in 2016, right?
I think it was Terrence Franklin was the last one.
Thank you. Yes.
They investigated themselves on and found they did nothing wrong.
Yes, Terrence Franklin in 2013, I believe. Yes. Okay. So the BCA has started increasingly being the ones to do these use of force investigations. And actually in 2020, the legislature passed statute 299C 6.80, establishing an independent use of force investigations unit. This statute came after there was a lot of community pushback for having the BCA do these investigations at all. Some of the stuff that we found in our investigations over the years is that there's some problems with the BCA does their investigations. For example, there's a lot of leading questions in their interviews of witnesses. They will often abruptly redirect witnesses when they're coming to a point that might be unfavorable to the officer involved. We've also seen them not test, critical evidence that should be tested in some of these cases, like testing hands for gunshot residue when the person has been alleged to have shot at the officers. So there was a lot of pushback for the BCA to be continuing to do this, but nonetheless, this statute was passed. And the community continues to raise some questions about the true independence of the BCA's investigative unit. So who are the BCA agents that do these investigations? Most of them are former law enforcement in Minnesota. I think to be a BCA agent, you have to have at least 10 to 15 years of investigative experience for an agency before you can work for the BCA. And another important note is that the BCA provides a lot of aid to law enforcement agencies throughout the state. So for example, like small town agencies in rural Minnesota, they don't have the capacity to do murder investigations. They don't have crime labs. And so the BCA steps in and does those things for them. The reason we point that out is that's kind of a symbiotic relationship. And then it's essentially an extension of having the police investigate themselves. It's not truly a separation there. And another thing that Nicole has really pointed out, because she's done a lot of investigation into tracking all of these BCA agents who show up in these cases time and time again, is that a lot of them have been involved in their own deadly force incidents themselves. So for example, on the screen here, you have BCA Deputy Superintendent Scott Mueller. He is the agent in charge of the use of force unit, and he was accused in a lawsuit of lying about his own use of deadly force in a 2017 shooting of an unarmed man. That man actually lived, and I think that lawsuit's still ongoing. I haven't heard anything about where that's at recently. So, okay, so the BCA responds to the scene. They show up within a matter of hours. They investigate, they do the crime scene measurements, all that kind of stuff. They investigate or they interview the officers and the witnesses. And these BCA investigations can take anywhere from 3 to over 12 months. We've noticed recently that they've been taking longer. We don't know why that is, but it's just a pattern that we've noted. So upon the completion of their investigation, they write up a report and then they give that report. They're supposed to give that report without recommendation to whatever county attorney it is to review. Then what happens? Okay, so the county attorney takes it. So since about 2015, many counties have moved away from using a grand jury. And so a grand jury is essentially a special kind of jury where a group of people are convened to determine whether or not to bring criminal charges against an officer. It's a very secret process. You can't get grand jury transcripts unless you're in the midst of litigation. Otherwise, it's locked down in secret. And it's basically just, whatever the prosecutor brings before that grand jury, there's not a lot of transparency with the evidence that's brought in front of these grand juries. After Michael Brown was killed in 2015 in St. Louis, Missouri, there was a lot of pushback against the reliance on these grand juries. And our state responded by having county attorneys move away from that. And so now what we have is county attorneys review the BCA report and then they write a legal memo assessing whether or not to charge the officer criminally or not. And so in that legal memo, you'll have a statement of facts about what happened. Then you'll have the law about Graham v. Connor, that civil stuff we were talking about. And then they also do the analysis of the state law. It's only been in recent years that we've seen, honestly, since we've been doing our work and publishing our reports about challenging that officers could be charged criminally, but prosecutors are not. we've now seen them contemplate, okay, I could bring this charge. I could charge them with murder. I could charge them with manslaughter. I could charge them with battery. But then they have, you know, the thing at the end that says, well, we can't disprove the affirmative defense that they were justified in using force. So that's what we've seen more often than not in this case, or in this state. Okay, so looking at, again, some of the issues with the BCA, one of the things that we've noticed is that families who are, you know, the subjects of the data after their loved ones are killed, they're entitled to that data under our state's Minnesota Government Data Practices Act. They experience like increasingly long wait times to get that BCA's investigative reports, to get the body worn camera footage and other critical evidence. And so we have seen families wait like up to a year to get that data. And let's keep in mind, they have a 3-year statute of limitations. So now if they have to wait for the BCA to get done with their report, now they're at 2, and they have to go and try to find an attorney who will look at this evidence, which takes a long time. With our investigations, it takes us just about a year to do each one. So this waiting really runs into that statute of limitations. And in 2023, 5 families who had had somebody killed had tried to get data from the BCA, and who the county attorneys had actually cleared the officers of wrongdoing at that point. They had filed a lawsuit against them for withholding that data. Go to the next one. And so I have like a good quote here from the attorney on this case, Paul, who said that these families have heard the police press releases, the police union statements, and the county attorney's rationales for not charging the involved officers. And that's what their neighbors heard too. They couldn't defend their loved ones' names or begin putting their grief to rest, because even though they were entitled to the data about what happened, the BCA wasn't giving it to them. And for these families, they actually settled with the BCA to get that data, and I believe they've all gotten it now. All right, so that's kind of what we have here for talking about civil and criminal liability. We're happy to answer any questions that you guys may have further in depth about, you know, what it looks like when somebody gets killed in the state, what happens after it. Would love to just open it up to any questions that you guys have about these issues. Or online. Okay, sounds good. We have our next event coming up in the series. It's going to be a panel about understanding the qualified immunity doctrine, which is the biggest barrier for civil accountability in these kind of instances. We're going to have professors from St. Thomas School of Law, from Mitchell Hamlin, and a qualified immunity expert from a group called Americans Against Qualified Immunity. That's going to be here at the University of St. Thomas. It's going to be 2 hours long. So we're trying to figure out what time would work best in the day to actually do that, and find a good room to have a panel like that. But if you signed up for this event through the Eventbrite, you'll get some information in your email. Otherwise, please, you can reach out to any of us here about getting more information about when this series is coming up.
And all of these sessions are also streamed by King Demetrius. So you can always go on his site and be able to see any of the previous ones if you've not seen them so far. And then they'll also be being put on the Reinvestigation Workgroup, and you're free to please share them, get them out there. The whole point is we're trying to push back on this and educate the community. So like cases like Marcus's, we can push back and say, we do believe there's criminal charges that should be filed here, and we're not going to go away. So we need to, as a community, educate ourselves and start making change we talk about.
I'll ask you a quick question. One of the quick questions that I would ask is that, could you just explain to people how important it is to have the paperwork and have the facts about what happened in cases such as this magnitude? And not only that, talking about the Marcus Golden case, how it kind of like the time lapsed, if you will, it was running out of time, and a lot of lawyers wouldn't touch this case, and how important it was for you all to do a reinvestigation and find out the facts for a judge to be able to take the case on.
Yeah, great question. So the facts are essential. So like what happens when, like I said, when somebody gets killed is you'll have the BCA respond, and then typically the union or even the police department itself will issue a statement about like, okay, this is what happened. And we've seen a lot of times that they will already be asserting why their officers did nothing wrong. Like for example, when Amir Locke was killed by the Minneapolis police, immediately the city held a press conference and they put up this photo of the gun that Amir had to try to say, oh, well, he basically deserved it because he had a gun. And how dare you have a gun when police barge into your room at 2 a.m, doing an unannounced search warrant. And so the families, they really don't have any way to, defend their loved one or even to be able to understand what happened. I think that's the biggest thing when we work with the families that we do, is that regardless of right or wrong, they just want to know what happened. And the BCA is the one who has that data. They have the body worn camera footage, they have all the interview transcripts of interviews of the officers, the audio of those, they have the 911 calls, they have all of that information. And the families really need that to be able to process their grief and to be able to get justice for their loved one if they were killed unjustly. Um, as far as Marcus's case that you brought up, that was a big thing with Marcus's case. They held a press conference the day after, was the day after the day of he was killed.
He was killed at 2 a.m,
Yeah.
2-ish, a little bit. And that morning at 11 a.m, they had a press conference
Mhm.
where what they talked about is that it was a female 911 caller. So they were trying to make it look like a domestic. Okay. But it was a male 911 caller. It was a man who called in, and the female was nowhere near the situation. But it was already, that spin was already starting to go. And there was numerous things about that situation. They also had the press conference about 15 minutes after they had gone over to the family's home, Marcus's grandparents' home, searched his room, found another gun that he legally owned, brought it back. In our opinion, what we believe happened is all of a sudden then they said, oh, there's a gun in the car, and it was in the wheel well. Well, there was X amount of officers already there.
Mhm.
And if they had this is my first thought on this. So you have this vehicle and you have all these officers walking around and they're saying that they can see a gun in the wheel well that's covered by trash, right? Well, if I'm a crime person, I'm supposed to be taking evidence, right? I'm supposed to be doing this. I'd take a photograph of that. There's no photograph of that. What there's a photograph of is a gun with no garbage surrounding it, just laid on top of broken glass. Very visible. But in the reports, the officers talk about how they couldn't quite tell because only the handle was sticking up. So their own description doesn't match any evidence crime files that you can match up. But yeah, we know that they had gone over, searched Marcus's grandparents' home. He had a gun that was then no longer there, according to the family. And the next thing you know, there's a gun in his car, and they're having a press conference 15 minutes afterwards. Now, can you line all this up and say A equals B equals C? Well, we can't do that any more than they can tell us that when they're saying that there's a gun in that car covered by garbage, where's your proof? You guys had cameras. Why did you not take a photograph of what you claim you're seeing? Instead, your photograph doesn't match your description. See, it's got to work both ways, And that was the first thing that I kind of went, wait a minute, we got this event going on where they're over searching. We know they were looking for a gun, according to the family, because the family was there when they were doing it. And then the next thing you know, we're having a press conference at 11 a.m., 10 minutes, 15 minutes after they arrived on scene from the grandparents' home. And the only thing they found in the car, it took 2 minutes? They said, oh, there's a gun here. That nobody else took photos of inside the car. They waited till they processed it and took it back to the processing facility. I mean, there's so many things that I myself going, as an investigator, this is so simple. Why are these not lining up? Because that's one of the main things we do is we want to prove the police narrative. That's how we do this. Let's just take it step. If they're saying this is what happened, if Officer A is telling me he saw it and there was garbage surrounding it, and Officer B is claiming he also saw a handle sticking out from garbage, then Officer C, who's walking around taking photographs that day, well, A, B, and C, it's all lined up, but we don't have that. We've got A and B, but there's absolutely nothing to collaborate that. But we do then have this stuff. So that's the important thing for the families. The families are going, okay, wait, I know they were over here and I know this happened, but they don't have the tools to put this stuff together either because they're only knowing what they experienced. And they're not hearing from the investigators because they can't talk to the investigators. They can't tell them what's going on. So that's why this data and getting it in the family's hands and then getting the family to be able to get somebody who can help them legally for themselves. Because at the end of the day, we should all be wanting a truthful, accurate, and factual investigation, right? It should be following the law and it should make sense. I've done over 20 of these and I'm very concerned about what I've been reading. I'm not an attorney. You guys are all sitting here in law school. I'm very concerned about what I've read in these cases, and we all should, as a community, be demanding actual information. And I think we live in a world where we have a myth of policing that we believe this is going on. And that's what I thought when I sat down and first started doing this. And I started reading these going, did I get the wrong report? Did I get like the abbreviated version? I must be missing pictures. I must be missing this. No, I had everything. And the one thing I want to say about Marcus Golden's case, the part that I can't stop getting over is legally, criminally, I don't know how you can shoot somebody from 100 feet away. And he shot in the back of the head and came out the front of his eye and shot in the arm. 2 locations, one on the arm and one here. And that's not a criminal situation. So I myself will not stop fighting for that because I do believe it's criminal. And until I can get that specifically answered, I'm with the family all the way. And I think as a community, we need to push these county attorneys and stop pretending it's not political in some way, shape, or form. We as a community should have some form of trust in their reports, right? I mean, that's legally what they should hand us is a report that we can all trust. So that's, I don't usually speak for a reason, but that's my thoughts.
You did a great job.
I hope that answered you, King.
Nope.
Where can we find the recordings for the previous sessions?
Oh, yes, it would be on King Demetrius Pendleton on the Listen Media page. One name, King Demetrius, KingDemetrius, last name Pendleton, Pendleton.
On Listen Media.
Yep.
And you should definitely follow King's site. He is one of the first typers who've been on the scene for years and years and years. So he has many stories of his own and tells a story over in George Floyd Square. I think you should all go check out with his work, and it's amazing stuff. And we very much appreciate him doing this series with us. We couldn't do this without collaboration. So. Any other questions that anybody has?
Well, you can get involved in our work through the Community Justice Project Clinic here at St. Thomas. We have some lovely students who have been working with us with the Reinvestigation Workgroup, as well as with the Minnesota Justice Coalition, who is one of our partners as well. And then you could also just volunteer with us. You can get Minnesota Justice Foundation credit hours if you are a part of that. Or just do it on your own time. That's always an option too. You can find us on social media. Please do. We will keep you updated on the cases that we're involved in. We meet weekly on Friday nights from about 6:30 to 8, and we just spend our time going in depth into pretty much one case at a time. And we also talk about other issues related to policing in the state of Minnesota. And yeah, and ending qualified immunity, that's the other thing. Under the umbrella of the Minnesota Justice Coalition, we are pushing forward legislation to end qualified immunity in the state of Minnesota. How we're doing that is we're introducing a state tort claim so that you can file under our state constitution there's a remedy for violating somebody's constitutional rights under our state constitution. And so that gets around the federal problems with qualified immunity. We're in that bill, we're doing it for all government officials because it's not just policing that qualified immunity affects. It also affects actually a lot of cases involving the First Amendment. So if you're interested in that, we'd love to have you a part of pushing for that. We're actually going to have a press conference on Monday at the Capitol, I think at noon, about our legislative items for the year, and especially for the 5th year anniversary of George Floyd being killed. We're trying to push forward and get the legislature to do what they promised in 2020, which was systemic change. They made some other changes, but it doesn't get at the root of the issue with police violence. We believe that only ending qualified immunity will do that. So.
One last thing, if you are interested in learning about these cases, you can find our work of what we came up with for these cases on our website, the Reinvestigation Workgroup, as well as the lawsuits themselves. You can, look them up and read them, and I highly recommend doing that. It's really, especially the murder section, it's interesting law, it's interesting facts, it's interesting to read. So I would highly recommend checking out all the cases that we have done. Thank you, everybody.
Thank you, everybody.
Thank you.
Thank you, Jenny.